handle it by the members of the Defense Committee. And then, too, you were not in the meeting. And then, too, Chair, the committee did not summon General MK. What we ruled was that the minister and the PS were supposed to come with a representative of those offices that they administer. And we had the deputy CDF. And that is what happened. Then, too, why the bill was withdrawn, it was withdrawn after the Supreme Court ruling. And that is why, with the wisdom of the Speaker, we have a joint committee today, because the Supreme Court ruling is in line with the legal committee. And then for us, the Defense and Internal Affairs Committee, we handle the military and the civil force in line with that. So I don't see any problem with that. Otherwise, about CDF and any other thing, that one we ruled and it was closed. Thank you.
Chair, before, Chair, as a member of the committee, I want to distance myself from what our vice, and that is why we adjourned actually the sitting at the moment, so that in person he comes and addresses our concerns we had raised in that committee. However, Chair, because we are dealing with the UPDF and is in line of command, I do not see if there would be any reason why he would not be consulted on such a case, where he is in command, and I would not see why he personally would not appear even before this committee.
Okay, let's conclude the matter because we need to go for lunch and report back at 2.
Marshal, to share with them the same spirit, not in bad faith. The CDF should come and appear before us so that we consult him. Thank you.
That you were made the chair because you have capacity to guide this committee. And Mr. Chairman, I take exception of the character of some of our colleagues that when a question and guidance is sought from you, members jump in and even make rulings on your behalf even before you say anything. But having observed what is happening here, I want now to formally move that this committee resolves to request the Chief of Defense Forces.
Honorable Namboze, you rose up on a point of guidance.
I'm moving a motion and I'm being intimidated. I don't know why.
That guidance yet. Can I give my guidance?
Yes, please.
Give guidance, Chair. My guidance is that, first of all, it was the Defense Committee, yes. Defense and Internal Affairs. That is very clear. Number 2, we now have a brand new bill. Actually, me, I'm not privy to the previous bill. We now have a brand new bill referred to a completely different committee, and that is the Joint Committee on Legal and Parliamentary Affairs and Defense and Internal Affairs. So as it is, matters of the Defense Committee, Defense and Internal Affairs, will be handled in your committee. Yes.
Okay.
But also to advise further, I think even ordered the appearance of the CDF in error, because what you require is the move of the bill. Once you have the move of the bill, any other officer in the department does not really have to appear. So what you needed was the move of the bill. Once we have here the Honorable Minister of Defense alone, me, I would proceed with the bill. So the other officers can just be able to help
Mr. Chairman,
the submission of the minister. So for us, we have handled it that way. We received the minister, and that is it. So that's the guidance.
Thank you, Mr. Chairman. Yeah. Mr. Chairman, with the new bill, I wish to move that this committee interests in itself to interfacing with the Chief of Defense Forces to enrich the business of this committee, because, you know, he's the overall commander, and I think everything else, even the court martial itself, all whatever we are putting here will be under his direct.
Procedure.
Chair.
Honorable Namboze, we invited the mover.
But why are you so? Why is it that you are so sensitive? Even by just the mention of the word CDF, everybody here seems to be so troubled.
You move your motion quickly and we process it.
Mr. Chairman, I wish to move that among the people this committee interfaces with during this process includes the Commander of Defense Forces of Uganda, General Muhoozi Kainerugaba, to enrich the business we are handling here, because as the overall command of the forces, and this bill directly affects his office, that it will be very important if we interface with him. Mr. Chairman, I beg
justify quickly, in a minute, justify your... Yeah.
The justification is that, first of all, he's the overall commander. Don't intimidate me. Bring. I've been seconded.
Chair, I rise to second. Yes.
The motion is yes. Mr. Chairman, the justification I want to give is, you see, the army in Uganda, the armed forces are governed by that office. And this bill we are making this bill to facilitate the work of that office, and it is very important that the implementers of that bill are heard and have an input in making the law. Because, first of all, they are the people who know why we need such a law, because they are the people who are going to implement it. And in any case, they are supposed to enrich this debate, so that when we go to the House, because even previously, this Parliament had sought to interact with the CDF. So it would be very important at this stage that we also give him an opportunity to be heard, so that we don't get to hear him talking to the nation through the social media everywhere. We give him a formal platform for him to address us.
Derek say something about that. And then we can allow 2, 3 other.
I do not see it of any wrong to actually consult the CDF, the person in charge of such an act, the person who is going to implement, the person who will be consulted when it comes to the appointments according to the bill. I do not see any wrong of calling him for us to summon.
Invite entities and persons. The consideration for inviting entities and persons are basically 2. The first one is relevance. The second one, related to the first one, is value addition. This particular bill was sponsored by government. It's endorsed by a sitting Minister for Defense and Veteran Affairs, the Honorable Jacob Oboth. He is sufficiently competent, as you stated, to defend his bill. And he did defend this bill. We had questions for him that were asked. We still have questions for him. He's appearing at 2. You had stated this. I don't therefore see the value addition. First of all, the relevance of the CDF and the value addition over and above what his minister is going to state. Secondly, Honorable Chair, the army, the UPDF, is subordinate to the civilian authority. General MK is subordinate to a one Jacob Oboth, who is his political supervisor. After we have interfaced with the political supervisor, why must we look for subordinate officers? And lastly, Honorable Chair, in the command structure of the army, the commander-in-chief is the highest person. If we wanted anybody in the command structure, we should be looking for the commander-in-chief after the minister. The person we should be looking for is the commander-in-chief, not the CDF. And the motion is not to look for the commander-in-chief, is to look for a subordinate officer under the minister. I therefore find, it's my submission, Honorable Chair, that General MK is neither relevant nor will he add any value over and above what the minister presented.
Mr. Chair, thank you for picking committee. I saw an advert summoning interested persons to come and appear before committee and give their views. Mr. Chairman, I did not see a particular page which was summoning Moses as a person to come and appear, such that we assume he has refused to appear before the committee for us to force him to appear. So I thought he was not in particular summoned to appear here. Secondly, I think there is an insinuation that the institution of the army is summarized to one man, which I think we need to really try to. The institution of the UPDF of the army is not one person. The same people believe the institution is one man. I think that is also not very correct. Thirdly, Mr. Chair, I don't think there is a question that the army has not answered. I don't think there's where we are stuck because the UPDF had failed to answer something. I don't think we have reached that level. Is there a question we have demanded from UPDF that have failed to answer? Or that question is contained in him, because we cannot force somebody whom we don't even need anyway to appear before us. Secondly, if there are challenges with the ministry, we cannot belittle the committee to go downwards. Mr. Chairman, I cannot belong to a committee looking for answers, you can drop down to the downer people. Like Honorable Bott has suggested, we go upwards for the answer. You cannot, we have started at the level of the minister. We cannot fall backward to a smaller person, yet we are dealing with the bigger people. What kind of answer are we looking for? What are we looking from down? We better go up instead.
Just to inform him, Chair.
I would think that,
Chair.
I think we are...
From the beginning, and the justification she had given earlier on was that the Committee on Defense and Internal Affairs, in the course of their duty, had summoned the Chief of Defense Forces. And I'm sure that was within their mandate, because they are a policy sectoral committee. Yeah. This committee is certainly different. By the way, we are joint, but under our new rules, we are now a committee. And this committee is subject to Rule 209, which we didn't make in vain. And I can repeat, subject to instructions by the House, the deliberation of every committee shall be confined to the matters referred to the committee by the House. And in the case of a committee on a bill, to the bill committed to the committee and any relevant amendments. Whereas I would appreciate the concerns of the Defense and Internal Affairs Committee, because this is within their mandate to supervise the Uganda People's Defense Forces. The mandate of this committee is certainly different, very, very different. It's about this bill. And I think we would rather proceed on the bill before we again go into issues which are a mandate of the Committee on Defense and Internal Affairs. And our colleagues on that committee, please handle your business. I hope you have the mandate under the rules. For us, we have nothing to do with it now. Ours is this bill. Let's proceed.
Thank you. So by consensus, let us, we are ending it. It's closed.
Chair, please.
By consensus.
Chair, please.
By consensus.
Chair, please. You know I was supposed.
Honorable Jonathan, yeah. But it is not right for me to say it is over.
Thank you.
Insist.
Chair,
you need to respect your chairman.
I just want to debate this motion generally and state as follows.
Yes.
That when we vote or take a decision, we should be guided by this principle. That witnesses that we want to appear before this committee must be witnesses that are going to add value, that are relevant, that are disciplined, that have fidelity to the law, that are subordinate to civilian authority, that are sober, and that they are in their sound mind. I thank you, Mr. Chairman.
You are becoming unruly. No, you have put up a motion. It has been debated. You cannot make a rejoinder after the debate. Are we now going to debate the rejoinder?
Because colleagues here have...
Not debate the rejoinder.
Yeah, you take charge.
So what do we do?
Mr.
Are you motion or not?
I'm
by
not
consensus.
I'm not dropping it, Mr. Chairman.
Okay, let's vote by voice.
By voice.
So those in favor, you will say aye, and to the contrary, nay. Those in favor will say aye, and to the contrary,
You are
nay.
still teaching us on how to vote. He
The
hasn't
nays
called
have
the
it.
vote.
The meeting is adjourned to 2 o'clock.
Ending of this meeting was that when the movers first appeared here and we had raised some issues, they had undertaken to go back, consult, and maybe come back with us with much more clearer ideas, which could be to stand by the original provision or make some amendments to clarify for us so that we can decide. And I thought that is the purpose for which they had returned here. But from your communication is that we are now going to consider this bill and take a decision clause by clause. And we are going to do this in the presence of the witnesses, in the presence of the brigadiers, in the presence of the colonels, in the presence of the captains, in the presence of the lieutenants. Chair, I have reservation. Are you doing this to intimidate members of the committee? Because this procedure is completely alien to how Parliament works, to how committees work. And I find myself really uncomfortable. Not that I can't make a decision, but that you have co-opted members who should not be sitting with us. And you have completely disregarded the principle of separation of powers and independence of Parliament. To the extent that when Parliament sits to take decisions, we should sit without any...
Honorable Jonathan, what you should be doing, we are all in this, you should be ordinarily attracting my attention to the provisions of our rules of procedure, and I concur with you. Where we have a disagreement, that one will be left to the committee. We shall convene as a committee and take a decision on it. So, to that extent, you should have just drawn my attention to that provision. So, where there is a disagreement, as a committee, it will be upon us as a committee in-house to debate it and then take a decision for your attention later.
Chair, if you allow me to finish, they are here as witnesses. Even where you think there is no controversy, their presence and participation already infringes on the principle of separation of power, and we do not know what will go in the minds of the members. We are discussing civilians being tried in military courts, and you have decided to even constitute the court-martial here. Before we even proceed, you have decided to constitute your court-martial here. I find it strange. So what I want to suggest is let's listen if they have additional issues they would like to clarify, like we had agreed, either in writing or to make submission where they would like to make amendments to our response, and then discharge them. And then we can start clause by clause and move on. That is my humble plea to you, Mr. Chairman.
No, that is okay, really. There is no problem. Ordinarily, because if we got a problem with a clause after they have left, again calling them back, I thought it would be tedious. So can we then say we are not considering the bill clause by clause, but then say let us look at clause 1. Is there any issue with them, such that they can be able to respond? Then we got clause 2, clause 3, and then after they have left, we shall then go back and do our usual clause by clause
in-house as a committee.
Chair,
For such that we are clear with them on all the clauses.
Chair,
Is that fair enough?
the mover came with the issues we had, we put to them. Some they miserably failed to convince us, to even answer. And they said, allow us retreat. I don't know what is that in military terms. When they have encircled you and you need to escape first, and then retreat and reorganize. It's something like that. That's what they told us here. So
Then
me,
they're
I thought
retreating.
now they have reorganized, so they are coming to, and then after that we discharge
They're
them.
expected now to bombard.
Whatever, whether area artillery or something, but that's what we had expected. If they don't have anything else,
Okay.
then the decision is with us to decide. We don't have to involve them when
Correct.
we are deciding.
Okay.
That's my plea with you, Mr. Chairman.
You want to say something, Honorable Fox?
We at one point need to dispense with attendance of the UPDF. I thought the continued participation of the Attorney General adds value. You see, we need to harmonize our position with the Attorney General on virtually every clause, so that when we go to the floor of the House, we're not picking up debates. We would have canvassed all the clauses with the Attorney General. So I'm amenable to dispensing with attendance of the UPDF after they have made their responses, if any, and probably the staff from the Attorney General's office. But the Attorney General is a member of Parliament. Even in his capacity as a member of Parliament, he should participate in these processes with us.
Okay, let's proceed. We will do clause by clause as a committee.
Who has the power here, who has this? We are in all this together. And I imagine we are making a law for everybody. Since they were last here, the other day, we have received, I think, 2-3 presentations, for which, in my view, you would have brought it to their attention. That, by the way, when you are here, we received this and this and this. What do you have to say about it? One, it enriches our position as a committee that they have now even an opportunity to seek explanation. And I'm not even looking at them, I'm looking at the Attorney General, because I don't know whether you are representing the Minister of Defense or you are together. And where is the Minister of Defense? Because to me, I don't want them to come, like Jonathan is saying, that the army is here. By the way, we don't have to get scared of this. Where should we? We leaders. Why should we be scared, to be intimidated by these ones? I don't think... I imagine... I imagine, but that is on the lighter side. Oh, this was LRA? I'm not comfortable with LRA.
Chair, after here, you asked Honorable Katundu to go to Makinda and just doing things there.
Yeah, but I was thinking that we should have the minister here, because this should be coming with their minister. And even if they are to make any contribution, it should be with their minister. If their minister is here, I don't think Honorable Jonathan would have any problem. That they are here, they can whisper to the minister and so on, because they are part of the delegation of the ministry, not here in their own right. You should be with their minister here, and once the minister is here, I wouldn't have any problem in putting some of these issues to the minister. He can consult his experts of the forces, and then we can move on.
The minister had indicated the difficulty to me of attendance, although he didn't say he would not attend, but issues this afternoon. And then he said that he had talked to the Attorney General, and the Attorney General would be around, and he was glad that if the Attorney General is around, the Attorney General could be able to handle most of the legal issues. But he assured me
Is he
the
standing in
technical
for the
people from
minister?
the minister would come.
No, I think the minister should carry his burden.
I think for me, as far as my understanding of the discussion I had with the chair was that we are coming to assist to understand the drafting and understand clauses. What did you mean by this? That's what my understanding was. When you drafted this clause, what was the meaning? For some clauses, that's as far as I'm concerned. I'm definitely, some of the things here I'm not competent to deal with, because some of them are technical, but I can tell you what the meaning from my side in terms of drafting is. So like you said, like members are saying, we are happy to answer any other questions, to also bring to you what we have added on since our last meeting here. And if you need us, we are available. If you want us to step out and allow you to go close by close, we are happy to do that. But we are comfortable sitting in with you, because after all, when it comes to the issue of drafting of the bill, it is us supposed to draft it.
Thank you, Attorney General. I ordered the clerks to ensure that we have enough eats by looking at clause 2. Clause 2 is
Chair.
an amendment. Yes.
Can I seek a clarification whether we will have the minister here? Because this bill is owned by the minister. Where is the minister? To me, that's the only one. This gentleman being here, I don't have any problem. But their head should be here at least.
Honorable member, the
Chair,
minister.
For me, I'll seek to check.
Honorable member, the minister discharged his the bill. We invited him to get back for further clarification, and he promised that he would try. But in any case, his technical officers would be here. And we are blessed that we have the Attorney General, who has admitted that he is privy to the drafting of the bill. So, I want to think that if we have the Attorney General who says he knows why the bills, the clauses look the way they look like, and we have the technical officers from the ministry, I think we can be able to proceed. If there is anything else, it's not ending today. We can still invite the minister on Monday for further clarification.
Chair.
But for now, let's get what we can get from the team which has assembled here.
Chair, the Attorney General has informed us that there is some additional information which is consistent with the adjournment we did on Wednesday. Some additional clarifications, some new submissions, what they have added, and that is what he said. I am okay receiving that. If the minister has also some additional submissions written, I am okay with that. But for us to go and start saying, close this, we discuss, and I am really uncomfortable. And I don't know what else, what other pressures is making you disregard the laws that you understand very well and you know, and what else are you trying to shock me with in this participation of this process. So I am only available to the extent of receiving the new additional information. Maybe they are proposing amendments which the committee can. But to start making decisions and discussions, and I told you, they appeared here. We asked, I have all the questions. I asked the ones they have answered well. If there is any member who wants to ask, that is okay. But we cannot go close by close. And I will refresh your memory. When I objected on Wednesday to the approach you had decided that we read the bill and receive, you said this bill, there is nothing controversial in it. We already know it. And let them present. I said, let them present close by close. It was your ruling. I said, no, just touch on the areas and go. So why are we doing things piecemeal? And you are the same chair who was here. So let's just receive the half and then we take a decision.
Honorable Attorney General.
I think, Honorable, let us present to you what we have. We can then let you go about your business, and then we can look at the report when it comes out, and we can always address our minds to it.
I think that's better. Let's listen to the Attorney General, and what you have, and then for us we shall handle the rest. Yeah, but I can be sure to understand every bit of the. But Honourable Attorney General, take the floor.
It is not your approach.
No,
it's the committee
okay.
approach.
It's okay.
It's the committee
Take
approach.
it easy.
But
it's
Mr.
fine.
Chair,
Thank you very much,
Chair.
Mr. Chair.
Mr. Chair.
Honourable Attorney General, you have the floor.
Mr. Chair, I'm sorry. Mr. Chair, still with due respect to our colleague Ms. Odur, he has raised a genuine procedure matter. Honorable Odur, with the draw, sir. I will still pray that even so, Attorney General remains with us for purpose of reducing our work rate and narrowing the gap for a lot of arguments which are not necessarily in the floor of Parliament. So I would beg that we retain Attorney General even after that. Although we don't mind the gentleman being here, but or do not expect that we have put a semi-court.
And also, any other clarifications beyond what was sought the other day? If there is any clarification you want the Attorney General to clarify on, or the generals, such that when they
After all,
we are good,
with us throughout.
we are good to go.
The committee had left us with 3 questions. Whether there was a lead judgment, the independence and impartiality of the court martials as discussed by the Supreme Court, and what the Supreme Court said about the trials of civilians. Honorable Chair and honorable members, we did communicate to you, Honorable Chair, the answers to these questions, and we did advise that yes, according to the judgment, there was a lead judgment of the Honorable Chief Justice, and we did set out the pages where it was stated. We did address the issue of independence. We have pointed out the pages on how the court guided that independence should be considered. It stated that the following elements should be considered in determining what independence is. That is the taking of the oath, legal qualifications, the manner of appointment, tenure of office, convening authority and prosecuting authority, and existence of other guarantees against outside pressures. Honorable colleagues and Honorable Chair, and I shared.
You don't have a copy of?
We sent.
Send it to who received it? Who received it?
Copy?
You ran and photocopy. Did you receive? You are sharing?
We shared electronically and sent them and a hard copy as well.
So, do you want the hard copies? Okay. Clerk, please.
Give me Article 128.
Attorney General clearly stated that he will be comfortable with certain discussions in the bill, and then the technical ones. He will not be, especially the military, on the military aspect. Now, if we allow the military to leave, since the minister is not there, won't we hit a dead end?
The military is not leaving. We have just changed the approach to say,
okay,
let us have the clarifications that the Attorney General has to make. If there are any clarifications from the military, they make, and then we can seek further clarifications on any clause. We interact, and then they can take leave. That's now the procedure. Yes.
Thank you.
But anyone from the executive without their political head policy, you know the practice.
No, that one will not obtain today.
let's proceed.
We will proceed.
Thank you.
Okay, I am just highlighting it. You can dictate the way you like, but I want to challenge that.
We are always receiving entities. Throughout the year, we receive entities here during the budget process, without the minister. So that one.
Thank you.
like to be, because what my brother is saying is going on record. And to determine where something is wrong or right, you go to the law. And when you are talking about the law, you go to the rules of procedure of Parliament, for which I'm honored and privileged to be the boss. I'm yet to see a rule that provides for that. It is a practice, yes, and if we are like diverting it from the practice, say, well, this is a practice, but I don't want somebody to say that we are deliberately breaching a rule, because as far as I'm here, the rules are here. If there is a rule being breached, and my brother Jonathan points it out, then you'll have to take a decision, because we cannot deliberately breach a particular rule. However, I don't see a rule that provides for that position. I said I'm chairman. I didn't say I'm the father is your word.
You said it here.
No,
you are running
chairman.
away.
Honorable Attorney General,
Yes,
can you proceed?
and
Honorable
being a
Jonathan,
chairman does not.
Let's
Is there
hear
a
from
rule?
the Attorney
issue
General.
is there a rule?
I was already answering you.
Let's hear from the Attorney General.
I was already answering you.
Thank you. We have pointed out the provisions. There was a lead judgment of the Chief Justice. We pointed out the provisions in the judgment where the court guided on what we need to look at in order to determine whether the General Court Martial is independent and impartial. And I said that the things that the judgments pointed out were the taking of the oath, which has been provided for, legal qualifications, which have been provided for, the manner of appointment, and specifically here they spoke about the participation of the JSC, which has been provided for, the tenure of office, security of tenure, which has been provided for, the convening authority and prosecuting authority. In the bill we have addressed, the convening authority is the chair of the court-martial, and the prosecuting authority has also been provided for. The existence of guarantees outside pressure, also objective impartiality. So these are the elements that the judgment spoke to determine independence. On the issue of the discussion on whether or not civilians can be tried in the court-martial, we have attached an excerpt. We have attached excerpts of every page and paragraph where each of the justices of the Supreme Court discussed the issue of trial of civilians and what guidance was given there. So, Honorable Chair and Honorable colleagues, those are the questions that were left with us. We've sent a written brief on that. We'd just like to point you again to a matter that was raised on Clause 57. On Clause 57, in the discussion, we talked about the drafting. There was an issue of drafting because the meaning seems to have been lost in the drafting, and we had proposed that the drafting can be revisited in Clause 2, where they say where a person has appealed. And in this provision, the discussion was, have we taken away the Supreme Court, the constitutional requirement for someone to go up to the Supreme Court where there is a matter of death? And we have proposed a new drafting to be included in a section in Clause 57 to read where a person has appealed under subsection 1. The person shall continue to serve the sentence imposed by the courts-martial until the appeal is disposed of, except where the person is granted bail pending appeal. Because I think we had that issue of what were we trying to say. So there was that clarification on the drafting. Honorable Chair and members, there was the issue on the military stores on Schedule 7. Schedule 7, I've been advised by the technical people that the requirement here is that these must be properly inscribed. All their stores would be properly inscribed with the marking UPDF. So if, for example, their shoes, they'll clearly be marked UPDF. So if someone is found with stores which are not marked UPDF, say like we discussed the black shoes, if they are black shoes and they are not marked UPDF, we are safe. Because I had also considered reviewing my wardrobe on black shoes. But now I think they have clarified that. So, no, for all the military stores, I think we need to include a provision in here which requires that all the military stores must be clearly marked with the inscription UPDF. And if they are not marked with the inscription UPDF, they are not military stores. Yes. So I think, Honorable Chair and colleagues, those are the questions that we were left with, that we carried away. We are happy to field any other questions that you may have on anything. Otherwise, we are also happy to take your leave and wish you great deliberation. Thank you.
Thank you.
We go for some cadre courses at Chankwanzi. And after the course, we are given the attire. And these attires are clearly marked UPDF. So is that part of... Okay.
Yes, so if you go for cadre courses and you are returned with military attire which is marked UPDF, that will be military stores. But what I was advised is that the ones that they use in Chankwanzi, the ones that are used in Chankwanzi for training of cadres and etc. are actually not marked UPDF. Yeah, but yes, but also, please, we must be mindful about one fundamental thing about these military stores. Not that everyone who is found with military stores commits an offense. You must have it without authorization. So if you authorize to have the military stores, you don't commit an offense. Yes.
Thank you. Seek some clarifications from Attorney General, because for me these are matters to respond to. Attorney General, under clause 30, under clause 30, let me just go there. Yeah, under clause 30, you created the bill creates an offense under clause 30, under section, which is amending section 117A. And so, section 117A, other person subject to military law. And you go to D, which is on page 646. And it says, where the person aids or abets a person subject to military law in the commission of or conspires with a person subject to military law to commit the following offenses. Now, these offenses are created here: murder, aggravated robbery, kidnap with intent to murder, treason, misprision of treason, or cattle rustling. So we've created these offenses here, but their ingredients are not anywhere in the law. That is one thing which I want you to comment on. And you didn't make any cross-reference to the penal code where the ingredients for these offenses are well known to be. The other issue is the definition. Is first of all, here we create the offense of aiding and abetting, but in the same bill, we don't. There is no way I've seen where you create the offense for the principal offender. Where is it? At what stage is the principal offender brought under this act? Who are the military personnel? Because under the service offense is not defined to include these offenses. So the principal offender is not culpable for these ones, and yet we have created aiding and abetting. Is it clear? Have I made sense? The other one, Mr. Attorney General, is I can leave it at that. I'll be getting more. Yes.
Land Attorney General spoke to the, what is the technical word? Writing of the word UPDF. So does this mean the Schedule 7 is going to be modified, because that's not included here in the schedule, where you list items that a monopoly of the UPDF? That particular statement of inscribing the word UPDF on those items, it does not reflect anywhere in this schedule 7A.
Chair, I thought that it can only come from our proposal to that particular clause, and now they will have no objection because they have said, yes, that's what they want. Because they're not going to amend the bill now, but in our report we can propose that, and for which now they're on record to say they have no objection with that one. That was my understanding, Chair, unless I'm wrong.
Honorable Chair and Honorable colleague, I think only that when we interacted with the committee yesterday, they pointed out a gap in the law which could be abused. And we went back to consult and say, how do we address this? And they said the part should be that all the military stores must be properly inscribed with UPDF. And that has to be added into the bill in order for it to have effect.
I think the point is that in these pictures we cannot see how the UPDF will be written. Supposing U is put up, P somewhere in the corner, D somewhere, that's what we are talking about. It's upon you to do that.
Yes, and we are saying that we are asking, because this law is being made by all of us together. So you have pointed out, I think, first of all, we are saying that military stores are military stores, they should be for UPDF. So we are saying that no, in order not to have people confused as to what is military stores, they should be properly inscribed. Now, we can also take the guidance from the committee to say it must be inscribed in a space where, you know, that kind of thing. That we'll be happy to take.
Yes, Honorable Namboze. Let's have all the clarifications to the Attorney General. Honorable Namboze.
Thank you, Mr. Chairman. Mr. Chairman, I want to know now that, for example, the issue of the bellet, as long as the bellet does not have that insignia or emblem, then it's not UPDF. Or another government store, but I just wanted to use the bellet as an example. And for that purpose, I would like to propose that the UPDF goes ahead to provide for that that mark emblem, the way it will look, and we include it in the bill. The design, so that it can be included in the law.
Yeah, that's correct. But honorable colleagues, and let us be careful as we write this law and understand the purpose for which we write it. For example, if I go out of Uganda, I actually don't get this military store from UPDF which is marked. But I go and I buy 10 of those uniforms. 10 of those ones. I have them. They are not marked UPDF. The reason why the law requires that you gazette them, so that the public is aware that these are military stores. For example, if I get out there and I find 100 people putting on this, and their answer to me is that this is not military stores, we may create a bigger problem than we are trying to solve. So the members of parliament need to be mindful of the purpose for which this law is written. The purpose is not to guard the UPDF stores and keep them in stores. It is to ensure that they are not misused in the public. If a person breaks into a house at night in that uniform, how am I to know whether it is UPDF or a thief wearing something similar to UPDF? So as you go through this law,
let us be careful to discourage the public from even using those things which are similar to military stores. So that's we are saying that the inscription may be there, but the purpose of the law is if I find you with military stores, that's the offense. But the purpose of the law is to disabuse people to even hold out. For example, all the time you see people in the media who are held and said, this person has been holding out to be a soldier. The person goes, buys uniform, material, he doesn't have UPDF, puts a flag, gets something, and moves around as a UPDF soldier. So that's the purpose of the law. So, colleagues, as you go through this exercise, we encourage you to have that at the back of your mind. Right now, it may seem like we are discussing the red beret right now. But how is he, the soldier who is guarding you, to know if he finds 100 people and all of them are just saying, these are not military stores. I bought my uniforms in a country X, and they don't have the inscription UPDF. So I think we need to have that at the back of our mind. And that is what I explained to you the last time we were here, that these things of similar to the UPDF uniform, you want to encourage people not to use them. Colleagues, we are going to get into a problem as we write this law, and we encourage people to just go to wherever because these uniforms are made in public facilities, which are open to the public. So if you tell them that you can go and buy your own which are not inscribed with UPDF, that is different. So there are things that we looked at when we were having this discussion, when we were saying, would it be reasonable for you to find someone with a black shoe and say it's military stores? Or a Kaunda suit and say it's military stores? And we said, okay, that's reasonable because we can have so many black. But would it be reasonable for me to find someone in that kind of camouflage for the person to argue it's not military stores? So that's what we need you to.
But I think, Chair, a person who has a criminal mind, since he can take advantage of the law and says if there's nothing written on it, it is not UPDF. A person who has a wrong mind can take advantage of that, go and picks one and come and walks. You get the point? And people say this is UPDF. I think here there's inscription like on shoes, but there are colors that are specifically earmarked for the police, for UPDF, for prisons. You cannot joke with those colors. We cannot bring those colors to be on inscription. There are colors which are gazetted. There's also gazettement and inscription. Yeah, there's gazettement.
So I think what we are saying here, some things which are common in use, like shoes, Kaunda suits. You would understand if a person is found in a blue Kaunda suit, and you say, coffee brown, say, but is this military store, is it not? Those are common use. But there are some things which are not common use. There are some, and when we make the clarification on these inscriptions, we shall show what is to have inscription and what you are expected as a member of the public to just leave on the side. Because we don't think that it is correct for us to send out a message to the public that since you can go and buy this uniform, you can go and buy berets, you can just put them on. Now, because it has no inscription, it's very dangerous. It's very dangerous, but it is left to you as the committee, because eventually you're going to have a clash. You're going to have a clash where you are in a crowd and you can't tell who is, who is the friend and who is an enemy.
It has been properly covered.
Okay, Attorney General, thank you for this interaction. All of us, for example, it's not just about green or what. For example, if you look at that color, it's not just one color. For you to go to a great extent to get a dress or a suit in that color, when you are not part of that, when you know ordinarily it belongs to a certain institution, I think that is really, there's something you are imputing, and when you make many of you to make the same. So, but I am really interested in the mind of the Honorable Attorney General. When you go to section
this bill, section 30. Section 30, 2. Section 32 says, a person referred to in subsection 1, that is the number of people there voluntary companies. That's where the 1A says that where the person voluntarily accompanies any unit or other element of the defense forces which is in active service in any place. That's 1A. And you go to 32, says a person referred to in 1A who, while accompanying a unit or other element of the defense forces, is alleged to have committed a service offense, shall, for the purpose of this act, be treated as if he or she was a militant of the rank of a private. I don't know how many of our officers here have served in Karamoja. On a daily basis, Attorney General, if there is an issue in the community or some cows have been stolen, what the UPDF, because there is this cooperation, civilian military cooperation, they run to the community and say, come and help us. Lead us where the footmarks have gone. These people have stolen cows from Agago, from Asholi. They track together until where they end the destination. Even in other offense situations, the UPDF, in the case of Karamoja, is heavily reliant on the local support of the guidance of young people in tracking, in movement, and so on. I don't know, in drafting this, are those the people you are targeting to make them liable to prosecution under this act? Because they are merely volunteers. Some of them are informants, some of them really are helping propping up the intelligence of our security forces. And if so, if they come to know, some of us, we, of course, as politicians, will tell them stop because you are liable to be prosecuted. And that will undermine the work of the security forces just by this provision. Because by the moment you take the next 2 steps, working with the UPDF, you are liable to prosecution. And this is, I don't know why this provision was brought. I can see also under 31D, the specifications of crimes, murder, aggravated robbery, kidnap, treason, misprision, cattle rustling. I think there is also thinking there. You know, we have also had a law before, where 1963, where they say, why you get 2 Karamojong together, they're either from a raid or they are going to a raid. Please arrest them. Karamoja Act. So now, is this another law having eyes? Why? Cattle rustling is theft of cattle. So, but the way it is misused and misconstrued, it could actually even end up being targeting certain groups. What was the thinking here? Is this a special theft? How do you call a theft of cattle in what is happening now in Gomba? I think you saw the reports on the New Vision. There are cattle thefts on this side, in Yabushoshi. Will that be called cattle rustling, or that will be called theft? And the stealing of cows in Karamoja will be cattle rustling and subject to the military prosecution. So this is really. So are we calling now only theft in Uganda cattle rustling?
No, cattle rustling is cattle rustling. It's cattle rustling.
Attorney General, can we define it?
Let me finish. And it is not, you don't normally, it's predominant in Karamoja, but it is not an offense for only Karamoja. It's not an offense for only Karamoja. So that is one. The offense is not only for Karamoja. Once you start that exercise of cattle rustling, it can come down. It comes down to Teso. Even in Gomba, you started getting some of those incidents.
Even Muse's cows was stolen.
Yes.
Would you call that cattle rustling?
Yes.
So and then what happens to other laws? Not
Like-
talk about cattle theft or
No,
theft, theft generally.
Theft is different from cattle rustling.
Maybe we
They
need
are
to
two different offenses.
Then we need to define it in this so that
Okay.
we understand what
Okay.
it is. Because otherwise, we are making a law targeting Odur, or it's Odur making it in his favor. So I don't know, but let's define what it is.
Yes.
And who you are targeting. Whether theft, because it should be the same offense, whether you commit it in Kisoro
Or in
or
Karamoja.
something, not
Yes.
this one, cattle rustling, which defines, which is even geographical.
Yes.
And that means you make a law for us,
No,
or
no.
for the people of Kampala, what you call it. When a lights are stolen from a car, we call it what?
Service of- Now, this issue of 32 has got many scenarios. And when they say is alleged to have committed a service offense, this service offense, as we've redefined it, is the offenses under the UPDF Act. For example, if you disclose the location of soldiers, it is an offense under the UPDF Act. It's a service offense. You are in battle. You go and tell the people that the UPDF is in the Andach there. That's a service offense. Say they, yeah, wherever they are. Say you say that they are in this place. Yes, a specific location. If you go and pick the location of officers and you say this is where, that's a service offense. Now, if that person was embedded in this group of soldiers as an informer, for example, in the case you've given, but it turns around and goes and tells the people they are pursuing that we are behind the building now, that's a service offense. That's what they are talking about here. No, spouses can't be embedded in the operation. Cowardice. No, but this one, colleagues, is at least the UPDF operation are very much civilian-based. The operations of UPDF are very much civilian-based because UPDF works more with civilian operations. So wherever they are, they embed people. The duty here, if you remember, this is in respect of section 1. Yeah? Subsection 1, subsection 1A, where a person voluntarily accompanies a unit or other element in active service in a place. So you know you're going into active service. You voluntarily go there. So if you know that you're going to attack, it's a war, and you voluntarily take that step, then don't run away. So this is much...
A quick clarification. Honorable, just because this since personally for me directly, since 1993, the first instance of this kind was when Chef Alim recruited me when I was a student in Makere to help defeat the war in Teso, the rebel war of Ojirot. Actually, it's not voluntary, even now. It's a duty. Once the UPDFs have come to your village, you just said, all the young men lying, let's go, let's help us in this. And the fear here is that if you introduce an offense along the way, you have no defense. If you say you are voluntary, which you are not, and then you say you have been another offense lumped on you, it will be difficult and will create a difficulty in this civil-military cooperation.
Would it comfort you to know that this offense has been on the statute book since the inception of the UPDF Act?
And suddenly, personally for me, I didn't know because I was not in 2002 when this law was made. But
what I'm saying,
this comes alive and someone misuses it.
It has been on the statute book since the inception of the UPDF Act and has never been misused. So this is not a new offense. It has been on the statute book. If you look at your old statute book, even the NRA statute, it has been there.
Yeah.
It is not new.
So what is the new amendment here?
The issue here is we have separated 117 from 117A. 117, originally in the Act, 117 lumped together soldiers and civilians. What we have done in this amendment is we've put 117, which deals with soldiers, and 117A, which deals with what? With civilians. So that is the difference. 117 deals with soldiers, and 117A deals with civilians.
I'll let me look at them. Thank you for that information.
Yes.
Let me look at both of them again.
Thank you. Of 30, the chair raised the issue of the ingredients. The ingredients, if you look at clause 38.6, 38.6 gives the jurisdiction to try offenses under this act and any other written law. 38.6, that's where it is. So the issue of aiding and abetting is an offense on its own. For example, I can aid and abet someone in the commission of murder, and I will be culpable for the murder, but I'll also be culpable for aiding and abetting. But I may not have participated in the act of murder. Say, for example, I come and wreck the place for you, and I tell you now the person has entered the house, I leave the door open, you go in and kill. That person has committed the murder, but I've aided and abetted that commission of that what? Of that offense. So I'm liable for aiding and abetting. The court may not be able to get me for murder because the act of murder, I did not commit it. But I could be got for aiding and abetting the commission of murder. But then there are other cases of aiding and abetting where we participate together. So that's the thing that you have with 31D. 31D. So those offenses are provided for this side, and that is aiding and abetting.
When I listen, starting from where we left on, I get a feeling that we are mixing two issues. Whether there should be an offense or there is already an offense in our statute books for possessing military stores, okay, for example, or for aiding or for abetting, which is there. In our thinking, and I agree that there must be an offense. But we are discussing this in relation to who has jurisdiction over. Okay? So we are not contesting that these offenses should not be there. That somebody found with, say, example, military stores or this and this, or as aiding.
I agree with you.
So you should be addressing us in line with the justification why they should go to.
That's another question, because for me what I was answering were the questions that were put to me, but I'm happy to try and answer that, why they should go to the court-martial. Let's start with aiding and abetting. Let's start with
one of these active service offenses is that if the UPDF is deployed in the cases of emergencies, aid, and there is flooding across the Adnebi Bridge, which is all in Bududa, that is active service, and then there are civilians helping them there. And then in maybe the distribution of posho and something to the civilians who are displaced, or the iron sheets from maybe OPM, and some civilians steal these iron sheets or find these iron sheets in their homesteads. But it was during the active service of UPDF. So you are saying they aided. So they would be part of this, just as an example.
No, because they stole. They did not act with any soldier.
Say they are with soldiers.
Are they stealing with a soldier?
No, it's the soldier who was stolen,
Yes.
but was in the company. The soldier was deployed in active service of providing relief or something like, which is their mandate. But also there were civilians, and the soldier somehow finds a way of stealing, because it's an offense, and now is subject to the court martial. And then this civilian who was part and parcel, aiding and abetting in the context, they would also go to court martial?
Yeah, because for aiding and abetting, we have said you aid and abet not the stealing of iron sheets, but murder, aggravated robbery, kidnap with intent, treason, misprision of treason, and cattle rustling. Let us use another example. A civilian is embedded in an active service of distributing relief. Then this soldier and the civilian leave this town and they go to a person's home and they kill the person. Yes, that civilian and the soldier will be subject to military law, but not for stealing iron sheets. And that is why 30D, 1D, has clearly stated what offenses you aid and abet. So if you aid and abet a soldier in the commission of any other offense which is not stated here, you don't go to the court martial.
So when we refer to the Act, the UPDF
Honorable,
Act, are we referring to only the provisions here or in addition to what exists in the law?
We should know that we have so many colleagues who have issues, but you ask
About people in his mind who have already been convicted. He's not talking about suspects, because we should put in mind that we are talking about suspects. Just because you are chosen does not mean that you have committed the offense. These people remain suspects all through until they are convicted. But the way you are addressing it, it is as if that when you are suspected of doing something that you say, when you have killed, but it is just an allegation and it should remain an allegation. But the way you constitute it is as if this person has already committed an offense, and that's why he should be subjected to military law, because he has already done this thing together with the army man.
Yeah, I think maybe my explanation is not. I think the issue there would be suspicion, allegation of the commission of the offense is what leads to the trial. So before you can go either to court martial or civilian court, there must be a suspicion, and that suspicion should lead to a trial. So you're correct. So what we are saying here, that's why in all cases we are saying is alleged to have committed, is alleged to have committed. But the allegation should have some basis. Honorable Chair, could I ask these
Honorable General, before the service officers come in the morning session, the Honorable Remigio gave a scenario in Karamoja where cattle rustlers, one of them, say, shot and killed a UPDF officer. And because of their way of living, they live communally. And then UPDF comes and rounds up, and it takes up 30 from that homestead. And all of them are tried in the general court martial. And usually it ends into a conviction and sentenced to a sizable period of time. Now, by way of scrutiny, the general court martial, and we have seen the conduct of these courts, even here in Kampala, leave alone the unit court martials and the field court martial. Even here in Kampala, the level of tolerance that has been exhibited may not sufficiently allow evidence to be brought to determine who is innocent and who is guilty. In most cases, there has been that omnibus conviction, especially in cases where there has been such conduct. Now, the worry here, why we need this justification from you, the Land Attorney General, why these civilians should go to the court martial, is because we are alive to such scenarios that have taken place. And we have the duty to convince the rest of the House to agree and believe with us so that we also believe with you. And that's where we are struggling.
Punto requested you to raise with the Attorney General all the issues that we had collected from the entities that we met yesterday and today. Now, don't you think this is the correct time to summarize for the Attorney General the critical issues that we got from those entities so that he addresses us on all of them?
I think for me the most important issue that I see in this whole thing, in this whole process, is how do we build the confidence of the public that when I am taken to the court-martial, I will be treated justly. I think that's what you're raising, and I think that's what I keep saying, and I think that's what we are trying to do in this process, to say, how do you appoint them? How do they get independence? How do we ensure that they are not interfered with? How do we? That's how we can build the confidence that what these people will do, that does this person actually know the law? Is he following the law? Are the rules being applied fairly across the board? I think that's the most important thing. But the greatest...
No, AG, the most important conflict must I, a civilian.
It becomes...
With a country...
It becomes difficult for me to answer if every time I'm trying to develop a point, you come in and ask why. Because the why is not an answer you can give Z. It is an understanding of a society. This Uganda you're talking about here is the only peaceful place.
Attorney General, you talk for 5 minutes uninterrupted.
Yes.
So that you can develop your point. Because
Yes.
that's the crux of the matter.
Yes.
No interruptions.
This Uganda that we are talking about here is an island of peace. Every side we are dealing with is chaotic. The ease of proliferation of arms into a place like this is huge. Now, laws are prepared for two reasons. The first and most important is deterrence. That's the first and most important. You do not write a law for people to commit and find out how it will be done. Deterrence. The second one is punishment, whose effect you're supposed to have correction. So, as you write this law, the government is telling you that for us, the biggest problem we are having is illegal firearms. Illegal firearms in our system. These illegal firearms are one thing when they are with civilians, but it's also even another thing where you get the soldiers to participate in committing the offenses against the public. And this is not without history. The history is there and we know it. So what the government is saying is that these people who use these illegal firearms, in concert with soldiers, let us deal with them as what? As soldiers. But we are not saying that soldiers should not be treated as human beings. Soldiers also need fairness and justice. Hence, the processes we are going through to make that available to the soldiers as well as civilians. The question that you're asking is, why do we have to take them to the court-martial? Two things. You're discussing guns, the court-martial are the ones who understand guns. So if you're talking about the use of violent means of doing things, the people who understand the violent circumstances under which those things can be done are soldiers. So if I'm going to go and ask a person, why did you shoot? I was under threat of attack. Was it self-defense? The soldier will be able to understand whether this was self-defense or it was not self-defense. In this circumstance, what would I do? So we are saying that the civilians
who want to be civilians should stay away from firearms illegally. If you want to get a firearm and you're a good civilian and the law allows you to get a firearm, go, apply, obtain a firearm, and use it lawfully. But if you want to go and get a firearm illegally, let us go and deal with the people who handle the firearms. So the expertise in dealing with firearms, in our view, is with the military. In fact, you'll find that many times you would even require the civilian courts to call in the expertise of soldiers in many of these cases that have been happening in civilian courts. Even for these cases of aggravated robbery, which gun was used and etc., they go to the forces to get the expertise to assist in determining these offenses. So the why is historical, is situational, and is expertise. Now, the issue that Parliament is going to be saddled with is, under what circumstances should I even consider this to be? Because I do not take the view myself that there should be no circumstance under which a civilian should be tried by the court-martial. We just use the example of aiding and abetting. You're going to create just confusion. There's a soldier this side and a civilian this side. Now, it is also not palatable to say, let the soldiers come this side. So, the issue of the why, colleagues, we need to get back into what our situation is. What are we trying to do? What is government trying to do? Government is trying to get people away from illegal firearms as a deterrent. And that is why the law exists. But the law did not take away the jurisdiction of the civilian courts. This law does not take away the jurisdiction. It's just parallel. It's just parallel. So they can be tried in the civilian courts. They can be tried in the what? In the court-martial. The preference of the army would be, if these people are using firearms, let us deal with them. Let us deal with them. And that takes us to the question, if that were to be done, say if Parliament were convinced that we may have a situation where we need to try a civilian, under what circumstances should that be done, and what are the tenets that we put in place to ensure that that person is treated fairly and justly, and the tenets of Article 28 are well taken care of. So, for anyone sitting on the other side and sitting outside may say, but the civilian courts can deal with them anyway. The civilian courts can deal with them anyway. Yes. Well, you can have a situation where these violent persons that we are dealing with, because by a person getting illegal firearms and etc., and dealing with them and doing aggravated robbery and etc., why should they be in civilian arrangements? Because they have voluntarily assumed a militant position. I go, I get a firearm illegally, I have assumed a position. So,
are you done with that explanation?
I think I'm done, and I hope before I finish up my 5 minutes, I would like to request that you allow they are not finished.
Let's have the generals come in on that.
I want them to just come in on the issue of aiding and abetting and their experiences on the aiding and abetting. Where I told you yesterday that when you appropriate funds to train these people, the weapon is not in the gun. The weapon is in that human being. That human being is trained to become a weapon. And if that weapon is allowed to roam in our civilian spaces with civilians, and you ask them to assist the civilians or to work in concert with civilians. You know, with civilians, when they come to your home, you may be able to throw a stool, and the person may not have the skill to dodge the stool, but this person has the skill that you have trained him to. So we are saying this law is telling civilians, please, if you get in concert with soldiers to commit an offense, you are taking yourself to the court-martial. But it is not saying that if you commit the offense alone, you'll come to the court-martial. No, 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 no. If you commit it alone, you go to your civilian courts and deal there. But if you get in concert with soldiers, you come this way. And like you said, the processes may not be so. That's what we are going to clean up. But let Wandera please just quickly explain the issue of aiding and abetting and your experience, why you think it is important that these civilians who carry illegal firearms should be tried in a court-martial.
Thank you very much. Well, Honorable Chair, I just want to give way back in the year 2007, robbery, aggravated robbery for that matter, took place in Stanbic Bank here in Kampala. What happened? An employee, a staff of Stanbic Bank who had two cousins who are members of the Uganda People's Defense Forces, conspired with them, planned to cause robbery by using the two cousins in the Stanbic Bank. First and foremost, he stole an identity card from a colleague, a fellow banker, and he armed it with one of the cousins being a UPDF soldier. He thereafter went and forged another Stanbic Bank in the names of one of other employee of Stanbic Bank, which he handed to the other cousin of his. I said there were two cousins. He thereafter went and forged the Stanbic Bank apron, a uniform, part of the banker's uniform. He swore them, had them sworn, and he gave them to the two cousins who were soldiers, and told them, you will hide your AK-47s under those aprons. And he took them to the Stanbic Bank on a Sunday and told them, come Monday, you will use this entrance. And he told them further that the one who had the stolen identity card should be the one in front, followed by the other whose identity card he had forged. And he told them, when you are about to enter, call me and you alert me, in other words. This came to happen. Go straight to the right. He further told them that as soon as you gain entry into the bank where I am, put us at gunpoint, order us to lie upside down, looking down, help yourself in the bank, and that they are trained. He further told them, we bankers are trained not to resist when there is aggravated robbery. This robbery came to happen, and Stanbic Bank in 2007, perhaps some of you could have heard of it, lost a lot of money. Now, what sold this civilian is that the bank manager, among whom who were put at gunpoint, shortly after these cousins had robbed and left, he followed them. But the bank manager had seen him as if signaling to the robbers. So after some time, when they realized that the robbers had helped themselves and left the bank manager was the first one to stand up, and he asked, where is so and so? This other banker who aided. All what I have told you, those who are not lawyers, honorable members, the participation of the civilian is mere aiding and abetting. What is aiding? The stealing of the identity cards, the aprons to access them to the soldiers, all that was aiding. And what is abetting? Abetting is mere watching. Now, he did not participate in the actual robbery at all. What is robbery? The robbery is when you use a firearm to... Yes. Now, the robbery was committed by the UPDF soldiers. The two cousins are not the civilian. Now, Article 210 requires us, the UPDF, to instill discipline in the force. Here we are, placed in a corner. Civilians who are opting, as the Honorable Attorney General has been emphasizing time and time again, who feel they should associate with us, get some errant soldiers, aid them to do this act. Now, how are we going to ensure that discipline in the force prevails? And by the way, if you separated legally under criminal procedure...
Can you first complete that chain?
You are out of order.
No, I wanted to complete the chain of the story.
Conclude.
No, because
proceed, General.
Under criminal procedure, if you separated the aider from the principal offender, at the end of the day, you may not have any offense to prove. You will not prove the robbery. So they were taken to the General Court Martial and conviction. They were convicted, including the civilian, on aiding and abetting. The sentence now, as Attorney General was emphasizing, the sentence for aiding and abetting is much lighter than the persons who participated in the actual robbery, the ones who had the gun. That's what I wish the Honorable Chair to associate with you. Thank you.
The last round now. Let me start the last round and then I'll give you a chance. The Honorable Attorney General, the issue of tenure, it has been canvassed by some stakeholders to propose that 3 years is